Magandang gabi and welcome to Bench and Bar Manila, a podcast made by Claude Fable, 5. I'm attorney Ramon Delgado, trial litigator, for 30 years former prosecutor, and as always, my batchmate from Malcolm Hall, attorney Beatriz Santiago, constitutional law professor and appellate litigator. B. Tonight, we do something different. Day 4 of the impeachment trial of Vice President Sara Duterte, July 13, gave us a genuine clash, so we will argue it as a clash. For this episode, I stand for the prosecution, you stand for the defense, walang bawian. And at the end, we take off the robes and judge the day together.
Tanggap ko ang hamon mon. But first, the neutral facts para sabay-sabay tayo. The trial resumed today after week 1 ended early. The prosecution called its second witness, Attorney Jeremy Lotok, 50 years old, member of the bar since 2013, 12 years in the NBI, today the regional director for the Bangsamoro region. Here's why he matters. From February 2023, he was chief of the NBI Cybercrime Division, the very unit that investigated the Vice President's November 23, 2024 press conference, where she said she had contracted someone to kill President Marcos, the First Lady, and former Speaker Romualdez. Last week's witness authenticated the video. This one came to say something much bigger, na totoo ang banta.
And say it he did. Under direct examination by private prosecutor Amando Virgil Ligutan, Lotok told the court, first, that the NBI is mandated by law to investigate threats against the highest officials. Walang hinihintay na complainant, motu proprio ang investigasyon. Second, and this is the heart of my case tonight, he testified that the Vice President's own utterances, even before the November 23 press conference, show she had already contracted a person to kill the President, Liza Marcos and the former Speaker. Nag-deal in na ako. Her words, not ours. Lotok's conclusion, the statements were deliberate. Indicative of intent, a serious, actual, and real threat. Hindi ito biro, hindi ito soundbite. Iyan ang testimonya ng abogadong humawak mismo ng investigasyon.
Objection mon. Conclusion, kung hindi man speculation. Listen to what the witness actually offered. His opinion. Attorney Lotok did not meet any hitman. He cannot name a hitman. Walang inaresto, walang na-identify, walang kahit anino ng assassin sa record. His theory that the contract existed even before the press conference rests entirely on the Vice President's own words. The same words my side calls an outburst. And when a witness declares that the Vice President committed a crime, that is a legal conclusion. And legal conclusions belong to the 24 senator judges, hindi sa testigo. The evidentiary gap the defense exposed last week has not moved an inch. Still no hitman. Still no corroboration. Only a video, and now an investigator's certainty about it.
Fair, pero let me tell you why the certainty matters. Ligutan asked Lotok. Why was the agency alarmed? His answer should chill this court, because the threat as uttered is a standing instruction. Kapag may nangyari sa Vice Presidente, the order to kill activates. Any accident, any illness, any act by a third party against her, even one the 3 targets had nothing to do with, could trigger it. Worse, other groups could exploit it. God forbid, harm the Vice President precisely to detonate the instruction. And the mirror risk, any attack on the President, the First Lady, or Romualdez now gets pinned on her dahil sa sarili niyang salita. Lotok's word for where all of this leads, chaos. That's why this is Article 4, BEA. Hindi lang ito politika. It's a live national security problem sitting in the record.
At ito naman ang kontekstong gusto ng depensa na makita ninyo. Those words were spoken in the heat of November 2024, while the Vice President's Chief of Staff, Zuleika Lopez, was detained at the House, the ordeal the defense calls systematic oppression. And the defense has gone further. It says the remark came in response to Operation Romanov, an alleged plot against the Vice President's own life, and it has announced it will present witnesses to prove that plot. Remember the frame my side laid down in week 1. The burden of proof never shifts. He who accuses must prove, with evidence that is admissible, credible, and competent. An outburst under provocation is the stuff of mitigation under Article 282 of the Penal Code. Hindi ng other high crimes na kayang magpatalsik sa isang opisyal na inihalal ng 32 milyong Pilipino.
Then answer the fork, Bea. Kasi today the court sharpened it. Senator Judge Bam Aquino pressed your side to state its position on the record. Do you deny that the Vice President hired an assassin? And Defense Counsel answered, "We deny that, Your Honor." Good. Pero heto ang sumunod na tanong na gumugulo ngayon sa buong bansa. If there is no hitman, kung walang kontrata, then the Vice President stood before the cameras and manufactured a kill contract out of thin air. So pick one. Either the threat is real and that is grave threats, or it is invented, and the second highest official of the land lied to the Republic about arranging an assassination. Impeachment measures fitness for office, Bea. Alin sa dalawa ang katanggap-tanggap?
A clever fork, Mon, pero rhetorical, hindi legal. Una, a press conference is not testimony under oath. Kung ang bawat pagmamalabis sa harap ng publiko ay impeachable, walang matitira sa gobyerno. What Article 4 charges is grave threats. So the prosecution must still prove the elements. A deliberate intent to inflict a wrong, seriousness, and the absence of the very provocation the defense has been documenting. Pangalawa, exaggeration born of anger, an outburst, is precisely what separates a heated conditional statement from a cold-blooded criminal threat. The fork collapses into the same question the court started with, intent. And on intent, ang hawak lang ng prosecution ngayong gabi ay ang opinyon ng isang investigador. My client's language was ugly that day, pero ugly is not yet impeachable.
Let me concede the day's procedural stumble kasi sa panig ko ito nangyari. The prosecution, through Iloilo Representative Lorenz Defensor, asked the court to move NBI Director Melvin Matibag's testimony up to tomorrow, Tuesday, because Matibag wrote lead prosecutor Gervil Luistro that he flies out on July 20 for a regional summit on transnational crime hosted by the FBI and the Royal Thai Police, a practical request in my view. Pero umulan ng objection, and not only from the defense. Senator Judge Cayetano, the 21 of us are here. We set aside so many important things that might be a bad precedent. Senate President Gatchalian objected as well. And your side, Bea, through attorney Mark Vinluan, invoked the 5-day notice rule for witnesses. Presiding Officer Escudero noted na walang supina kay Matibag, wala siya sa listahan ngayong linggo, and deferred any ruling until the prosecution submits Matibag's letter.
Which the defense will happily chalk up as a point, Mon, rules are rules kahit kanino pa. And some color from the session, kasi buhay na buhay ang korte ngayon. Prosecutor Ligutan, mid-examination, slipped into Waray with his kababayan na testigo, prompting an objection from the defense. And this gem from Presiding Officer Escudero, I will let it go once in a while, but not each time. Less charming. Cameras caught senator judges leaving the session hall mid-hearing, sa isang trial na ang bawat isa sa kanila ay hurado. On the brighter side, the transparency push is real. The documents presented in evidence are now posted on the Senate website, and Senator Lacson is pushing measures to speed the trial up, including making the week's witnesses stay at the Senate para tuloy-tuloy ang takbo. Outside the chamber, retired Justice Adolfo Ascuna repeated his view that the prosecution has established criminal intent. Opinions outside, evidence inside. Dapat marunong tayong maghiwalay ng dalawa.
Robes off, Bea, honest scorecard. The prosecution got what it came for. A witness who says the threat was serious, real, and crucially pre-existing. That moves Article 4 from she said something terrible to she confirmed an arrangement. Pero the same witness is the case's soft spot. Everything he added beyond the paper trail is inference. The promise Ligutan made last week na may ihaharap silang testigo tungkol mismo sa Hitman is now a debt the prosecution owes this court. Until a witness connects an actual person to those words, the defense's "where is the assassin" refrain will keep landing.
Agreed. And for the defense, the day cuts both ways too. They scored on procedure, they kept the opinion versus fact line sharp, and the Romanov counter-narrative now has a promised witness list of its own. Pero we deny that your honor is a stake driven into the ground. The defense is now committed, on the record, to the position na walang hitman, and every future witness will be measured against that denial, starting with the most dangerous one. Zuleika Lopez, the Vice President's own Chief of Staff, expected on the stand Tuesday. The prosecution itself expects a storm of objections when she appears. Add the pending ruling on Matibag, at mukhang mas mabigat pa ang Day 5 kaysa Day 4.
The plain language summary para sa lahat. Una, the second prosecution witness, NBI lawyer Jeremy Lotok, testified na ang banta ng Vice Presidente ay seryoso at totoo, at ayon sa kanya, may kontratang umiral bago pa ang sikat na press conference. Pangalawa, the defense's counter is that this is opinion, not evidence. Walang hitman na naipakita, walang pangalan, walang aresto. Pangatlo, Senator Bam Aquino forced the defense to deny on record that a hitman exists, raising the question na hindi mawala-wala. Kung walang hitman, nagsinungaling ba ang Vice Presidente sa taumbayan? Pang-apat, the bid to move NBI Director Matibag's testimony to Tuesday was parried, deferred by Presiding Officer Escudero after objections from Senator, judges, and the defense. Panglima, bukas, si Zuleika Lopez na. Abangan.
And that's the deeper story of tonight's format, listeners. The same facts, argued from both chairs. And you heard exactly how far each side can honestly go. The transcripts and exhibits are on the Senate website now. Read them yourselves, form your own judgment. An informed citizenry is the whole point of a public trial. From one eskolar ng bayan to another. Salamat, Mon. This has been Bench and Bar Manila, made by Claude Fable 5. We'll see you tomorrow for Day 5. Magandang gabi.